All right.
As if we don't get started, we won't get through. And we need to get through this one time.
Okay. All right. I am Damian Leonard from the Office of Legislative Counsel. We are on section 12, page 14 of the first draft of the miscellaneous motor vehicle bill.
You look fabulous.
I tried.
Nice tie. Sorry.
I know you're not talking to me. So this is going to license examinations, and the main piece here that we're adjusting is on line 20. We're adding in junior operators, so the commissioner may waive the examination requirement when an applicant holds a chauffeur's, we're adding junior operators, or an operator's license that is in force at the time of the application or within 3 years prior to the application from another jurisdiction where the examination is similar to the examination required in this state. So in other words, if you move here, you may not have to take the examination, assuming that their examination measures up to Vermont standards.
Yes.
So
CDLs, right?
no, this is not CDLs. This is regular license examination. So junior operators, we don't have a junior CDL license. So yeah.
Thank God. But I think we already do have a CDL for the rest of the class.
We should, yeah. So we should. I don't know for sure. I'm still getting used to these statutes, but I think our CDL statute is a pretty standard statute that complies with a lot of federal requirements. So
it is.
perfect. There we go. Saved by Senator Brennan. So that'll probably happen a lot this year.
I don't know about by me, but
So may I just ask a question? So
Yeah.
is there a list of states that this applies to when someone moves
That's
to
a
another
good
state?
question for the department.
Okay.
Um,
Oh, right.
we have an international.
Yes.
there's also an international driver's license provision. So yeah, this is just making sure junior operators are added for the reciprocity
Okay.
so that you don't go through the process of getting your license in another state and then moving here and having to redo it 6 months later. Particularly when you consider a junior operator's license is a pretty finite period of time. So that examination occurred pretty recently.
Makes sense. Thank you.
The next change, the department can go into the reasoning for this a little bit more. But right now there's a scheduling fee of $29 for the road test. And this is for a regular license. And you forfeit the fee if you have to cancel within less than 48 hours of the test or you don't show. But if you appear for the road test, the fee is applied towards your license examination fee. And the department is proposing to get rid of the scheduling fee and just do the license examination fee. Now we're getting to commercial driving instructors. And this is a pretty lengthy section. So the changes that you see on page 16 are technical changes. It's really just, I hate the phrasing pass such examination as the commissioner shall require. It's really stilted and legalistic. So I'm trying to, you'll notice with me as I go through these bills with you that I am trying to make Title 23 and Title 19 a little more readable. So you'll see changes like that periodically. On page 17, though, line 7, we get into the requirements for commercial motor vehicle instructors. So they have to satisfy the requirements 1, 2, 3, and 5 of subsection A, which are not have been convicted of certain violations or felonies, pass an examination required by the commissioner, be physically able to operate a motor vehicle and train others in the operation, and pay an application fee. And licensing fees as required. So, and then the additional requirements are if the commercial motor vehicle instructor is a behind the wheel or BTW instructor, they have to hold a CDL of the same or higher class with all endorsements. They have one of two requirements they have to meet. The first is hold a CDL of the same or higher class with all endorsements necessary to operate the commercial motor vehicle for which they're providing training. Have at least 2 years of experience driving a commercial motor vehicle of the same or higher class, with any applicable endorsements that are required for the commercial motor vehicle for which they're providing training, and meet any additional requirements that the state applies, or they have to hold a CDL of the same or higher class with all endorsements, have at least 2 years experience as a behind the wheel instructor, and meet any additional applicable requirements. So the options there is either 2 years of actual field experience or 2 years of instructor experience. And then for a commercial motor vehicle instructor who is a theory instructor, the instructor has to hold a CDL of the same or higher class with all necessary endorsements, have at least 2 years experience driving a CDL of the same or higher class with any applicable endorsements and meet any additional requirements, or hold the CDL with any necessary endorsements, have at least 2 years experience, and this is the important difference, as a behind the wheel instructor before they can become a theory instructor, and then meet any additional applicable requirements. So in other words, if you've been a behind the wheel instructor for 2 years and you've got that CDL and meet the additional requirements, you can then also get your theory instructor license. And the department can talk more about the reasoning behind these requirements. I'm noticing that on the next reader assistant setting.
Are they having trouble getting CDL from instructors?
That's a great question for the department.
I only asked the question, not for you, but for the other readers in the room.
All right. So our next section is motorcycle instructors. This is an instance where the state has a shortage of instructors. And so the requirements to be an instructor are being reduced in one instance. Instructors shall, instead of having 4 years of motorcycle riding experience during the last 5 years, have 2 years of motorcycle riding experience during the last 2 years. And the other changes here are just gender neutrality. That brings us to taxes, everybody's favorite topic. So the request here was to the way the section was set up, they had exclusions grouped in with other provisions. And so the request was to split it up so the exclusions were separated out from the other provisions, because they were all subdivisions in a list, and it was confusing because the exclusions, you went from exclusions to other parts, and I'll walk you through that. So what we've done is the 5A is now the definition taxable cost, means purchase price as defined in subdivision 4 of this section, or the taxable cost determined under section 8907 of this title. Subdivision B is now the exclusions. So, and now what used to be subdivision A is exclusion number 1.
Okay.
What used to be subdivision B is exclusion number 2. Within that exclusion, there is a minor change. Instead of the NADA or NADA official used car guide New England edition, they're using JD Power Values or a comparable publication to determine the trade-in value of the car. And then for the tax valuation here,
So that's a question for the
department
about why.
Yeah, they can answer why. And then instead of subdivision C, we now have subdivision 3, or Romanet 3, And then what used to be Romanet 1 and Romanet 2 is now Roman numeral 1 and 2. So
Great.
yeah, and this is all just formatting here. And then getting to the old subdivisions D and E, which is relates to refunds. And reductions in the taxable value are now subdivisions C and D. So it's really mostly renumbering the section so that the exclusions are their own subdivision. And then the change from the NADA values to the JD Power values for the tax valuation there. Otherwise, I'm not going into the details there just to keep us moving. The next section that we're changing, and this is a related change, this is section 8907, which you heard me mention a minute ago. And again, the change here is we're going from the NADA official used car guide to the JD Power values. And we are adding the sentence, the commissioner may develop a process to determine, and this is page 23, to determine the value of vehicles that do not have a clean trade-in value in JD Power values. And so my understanding from the department, and they can speak to this more, is that because JD Power Values does a clean trade-in value, there may be vehicles that because of their age or condition wouldn't fit a clean trade-in value. They can speak to that more. And then the last piece here is a clarification or two changes. The first is on line 9. We're deleting the requirement that the notice be sent by certified mail. And so now it can be sent by regular mail, and mail would also include email. And then the purchaser shall remit the same, which is the tax due within 15 days. We've struck thereafter, and we've clarified that to say after notice is sent or provided. So that is just to clarify, because thereafter leaves the question of, is this after the notice is sent or received? So that. And then the last piece here is in the same chapter there is the refunds. To be eligible to receive a refund, a person shall submit a request within 1 year after paying the tax, unless a different time period is set forth in statute for a specific tax. So,
I would love to know what this is about.
and I'm sure the department can speak to that in more detail.
I'm green tabbing everything and I have questions. So,
All right.
hold it back.
We're sure you're green tab.
Mhm.
We totally understand.
Okay,
We just need to get through.
I'm listening.
All right, we will get there. We're getting close. We're 55% of the way through. Next is refund upon loss of a vehicle. The only change here is we're adding the phrase or other proof of cancellation to the satisfaction of the commissioner, in addition to things like returning the registration certificate or number plates to the commissioner to prove. And this is for when you're getting a refund of your registration costs after loss of a vehicle. All right, moving on to page 25, non-real ID operators privilege cards. A lot of changes for gender neutrality here. And then moving on to page 26. Actually page 27, the actual substantive change. Here on line 8, to comply with the real ID laws, instead of saying the privilege card shall on its face bear the phrase privilege card, it has to bear the phrase non-real ID, because it's not a real ID meeting federal standards. Fuel tax refunds. We're circling back to earlier questions here. A lot of changes for gender neutrality. On page 28, we are changing the time period for the user to collect a refund. The user may request a refund, but in no case may a user collect a refund if requested more than 12 months The current statute says 33, so we're reducing the time period to collect that refund. Again, the department can speak to why they're proposing this change in the statute. All right, the next section, alteration of odometers. This is not a proposed substantive change in the law. This is a reworking of what was a very long run-on sentence into subdivisions so that it gets a little more clear. And also changing from the passive voice to a more active voice. So instead of any person who sells, attempts to sell, causes to be sold, we're saying no person shall sell, attempt to sell, or cause to be sold any motor vehicle, etc. And the et cetera being the list of other vehicles if the odometer, hubometer reading, or clock meter reading has been changed, tampered with, or defaced without first disclosing that information to the buyer. No person shall change, tamper with, or deface, or attempt to change, tamper with, or deface any odometer, hubometer, or clock meter. And then we've deleted the phrase gauge, dial, or other mechanical instrument commonly known as an odometer, hubometer, or clock meter, and also the explanation of what an odometer, hubometer, or clock meter does, because I think that's common knowledge. So it's just a lot of extra words that were in the old statute here. And then in 3, we're changing willfully misrepresents to willfully misrepresent. And then we've taken what used to be the conclusion of that very long sentence to say, shall be fined not more than, etc., to say a person who violates subsection A shall be fined not more than $1,000 for the first offense and not more than $2,500 for each subsequent offense. So technical changes there. All right, the next 4 sections are all technical changes, adding a cross-reference to the definition of conviction. So the first of those cross-references is added on line 14 of page 31. And we're just referencing back to the definition of conviction in 23 VSA 4. My understanding is that the department has encountered confusion about whether a conviction includes an adjudication. And the definition clearly includes an adjudication. So for purposes of these statutes, where the confusion has arisen, they're adding a clear cross-reference back to that definition to make sure that's clear. So the next change in 23 VSA 108 is made on page 32, lines 4 and 5. Then in 23 VSA 1709, we're making that change on lines 15 and 16 of page 32. And finally, in 23 VSA 1200, which is the drunken driving laws, that change is being made at the very top of page 33. And that brings us to a portion of this on drunken driving. So here, the drunken driving laws, as many you will know, the offense occurs at 0.08 or above. Unfortunately, the cross references back to that say above the limit specified, which would be 0.81 or at least arguably 0.81. So the change we're making throughout these sections is to say at or above the limit specified to make sure that that's clear that it's 0.08 or above. The other option, if you don't like at or above, is to say 0.08 or above throughout. And then just update that anytime you change that limit.
And go ahead.
Do you know if that was challenged? Like, is that from a court case or you just saw this or the?
This was, I don't know if this was challenged. This would be a good question for the department.
Okay.
This was something that was first highlighted for me by the department's counsel over the summer when we were working on statutory revision. We discussed whether this was a change that could be made in statutory revision, and it's because it's substantive, it could not. So that's my understanding of how it came here into this bill. But I don't know if that resulted from a change or a disagreement or what. The other changes here are just, there are a few gender neutrality changes sprinkled in. But as you look down, you'll see very little has changed in these statutes except to say at or above.
Highlight on page 35 is not, it's just, there's a highlight of the first word on page 35.
There is.
Mine?
Oh,
I didn't
not on mine either.
Oh, you got the digital copy.
Oh, yeah.
The word test is highlighted, I don't know.
Yeah, not sure why. Um,
Well, you must have done that. You drafted the bill.
yeah.
Maybe I.
Yeah, I'm not sure.
Sure.
I'll have to look back.
It's actually an Easter egg.
Yeah.
Found it.
Right, the test,
Yes.
yes.
Yeah, if you click on that, a virus will download on your computer. Yeah. I'll have to look back and follow up on that. On 1205D, there is another substantive change in here on page 37. So there's a notice given, a notice of intent to suspend. Currently, and this is something you'll need to call in the Judicial Bureau, or potentially someone else, depending on who this notice, who actually has control over the form notice, for the notice of intent to suspend. Because currently it says that the notice shall serve as temporary operator's license and is valid till the proposed date of suspension. The problem here is that if you have someone who is driving drunk and does not currently have an operator's license, that notice is legally purporting to grant, or is purporting to grant them a temporary operator's license. So you can imagine it's basically at least an arguable loophole where they're now being given a form by a law enforcement officer that says, here's a temporary operator's license, even though offense 1 was operating over the limit, offense 2 was operating without a license. And so that's something the department will speak to that more, but that is a potential issue with the current form. The problem is the department doesn't have control over the form, so you'll need other witnesses on this issue if you want to move forward on it. We're getting close. The next is updating the fee for bulk electronic records requests at 30.3 cents per record. The department can speak to the amount. My understanding is that this amount may already be being charged and that they're updating the fees here, but again, they can speak to this in more detail. And the last change, this is a fun one. So I'm going to take you down to page 40 first before we get to all the other changes, because that'll give you some context. So it says fractions of 1,000 pounds shall be computed at the next highest 1,000 pounds, excepting, however, fractions of 100 weight shall be disregarded. So what does all that mean? What that means is what you see reflected in the numbers here. And this reflects, I think this was someone's attempt to reflect the scale used by the department for the registration fees for these trucks here, where based on weight. And so gross weight of 6,099 pounds or less. So under 6,100 pounds is exempted. And then if you go from 6,100 and then if you go down to the scale down below, which starts on page 39, you see it's 1821 when the weight is 6,100 pounds, but not more than 8,099. So, but less than 8,100, and then at least 8,100, but not more than 12,099. And so that's what I think they were trying to capture in that really kind of confusing and oblique sentence. And so instead of trying to do that, where the actual weights in the statute didn't line up, we're just lining up the weights in the statute. So it's more clear and straightforward. So this is just transparency for what I think was trying to be captured there. But that's all of these changes here are just making that adjustment. So instead of saying 6,000 to 8,000, we're saying 6,100 to 8,099. So we're actually saying the exact weights that are on the scale for the registration fees.
But it's no fee increase. So
This is not a fee increase. So it's just clarifying the actual weights that fees apply to. And in fact, if you look at the statute but hadn't looked at that sentence, you would actually be paying less under current practice if your vehicle weighs, say, 6,050 pounds, based on the way the statute is worded, because it says if you're over 6,000, I'm sorry, if you said 8,050 pounds, because it statute says does not exceed 8,000 pounds, you pay 1821. But if you're over 8,000 pounds, you pay 2083, when in reality, the current scale is up to 8,099 pounds. You're going to pay that 1821, the lower fee. So I don't know. There's no real fee change, but for folks who are looking at this, they're going to see that if they're in that little gray area, the actual fee they owe is a couple bucks less.
They're no lower.
They're not they're in a lower class, which the department was charging them for already. And this is just making it clear instead of hiding it in a really sort of backwards wording of a sentence. And then the effective date is just a placeholder, effective date of July 1. Understanding that depending on the policy choices you make and how this progresses, that can and will likely change. So that's it.
Thank you.
You're welcome.
Mr. Chair, if we have additions that we'd like to ask to be in the DMV miscellaneous bill, how would you like us to move forward?
Truthfully, I haven't even thought about it yet. And, as we get further into this, if you've got additions, I think we'll pass them around the table and we'll talk about it. But at this point, I haven't thought about it.
Oh, okay.
So we do have, some board appointments that we have to, and sorry, Damien.
That's fine.
This, at this point, we're gonna move on to, some board appointments, and then we're gonna adjourn for lunch. So if you wanna go back to your office
Yep.
or whatever you had planned,
Perfect.
you are off our.
All right. Great. And I will see you guys when I
Thanks,
see you
Sarah.
next. And thanks for your time.
So we do have board appointments. Traditionally, what I found when we do this, it's really good to just call the person and say, you have been called, and I in my history, at least twice when I served on other committees, people got called and said, I didn't know, we didn't yell like that. Because there are so many of these that happen. And traditionally what has happened on the other committees I've been on is that if the person is within your district, you were the first one to do this. If they're not, and people would like to take them up, and just give them a call and chit chat with them for a few minutes to make sure. Unlike commissioners and secretaries and those, we will officially take a roll about all of them and do that. So let me start. The first one is, let's see, the Transportation Board. And it's David Atherton, and he's from Brandon, and there's nobody from Brandon here. Oh,
Yeah.
yeah. Do you know David?
No, but I thought there were only a couple from the transportation board.
Well,
So I'm
he's the first one.
Okay.
And it says, as a member of the Transportation Board for a term from and including September 26th, 2024.
Can you remind us what the Transportation Board does?
Well, we have,
I've been on it.
That's right, you're on it now.
I believe I am. That's one thing I need to double check. I need to get off
Right.
my term and sometimes I think it's February. It's appointed by the governor and what we do is when someone sues V-Trans and they aren't, able to come to a conclusion, then they come to our board, to the transportation board.
Do you also do appeals? The decisions?
Yes, because that happens when, in some cases, we had a lot of pothole issues a few years ago, and those came to us.
Do they all come to you or only if somebody like goes to the?
I think most
agency?
of them come to us and then they go to the, and then they're appealable. You know, I don't want to tell you the wrong
Sure.
way, you know, where they are, go appeal.
The damages to cars because of roads or disagreements with contractors.
Right, and then issues with railroads, come to us.
Lemon law still? No,
The lemon law does not, there's a separate
you-
I
board.
went to the court, it used to, but
There's like a lemon law.
Yeah, there's just, and
Right.
this, right, and the staff person for the T board also staffs the lemon law.
Yeah.
That's a new one. So we save money on the staff. And then something the T board used to do was do public outreach all over the state on a particular issue and give a report to the legislature, but they were concerned that the legislature wasn't looking at it. There's some really good reports too. That happened when I was first on it. We had a report on transit and and so they're still there. They're still relevant. And they could do that, but it's not really part of the program now. And because they have the lemon law, well, because the staff person has the lemon law,
They
it
used
might
to
be
have a
difficult.
lot bigger portfolio than they have now.
Yes, but their authority actually has increased. It increased when I was on the board. There were some legal decisions that I'd rather someone else explain so that they get it right, but we had more authority than we did. No, it's yeah,
So since you had, would you? take
Sure.
David and Megan is tracking down the phone numbers for.
I have,
okay.
Oh,
I have
she already
emails
has.
and I have emails and phone numbers. How many do we have?
There's 5 or 6 here. So Richard Cleveland is the public member of the Travel Information Council. And he's from Northfield. Would you like to
Let them know what's been-
just let him know are you up for this?
What does that group do?
Travel Information Council, I don't know. I was gonna ask.
they do a lot about with signage, like billboard laws and stuff like that.
Yeah.
And I'm sure they have a broader portfolio than that.
Oh, yeah, I think they like the brown wayfinding signs and they like,
Yeah,
restaurant ahead.
yeah,
I think they approve those, so that's where you apply at your business.
Oh,
I think.
And this is Elizabeth Kenneth from Rochester. Is Rochester in your district? It's in,
No longer.
it's in,
It's in Addison. I'm happy to take Rochester.
and this is another Travel Information Council.
We want the people of Rochester back.
From your district?
So this is Marilyn Miller, who I think we all know.
Yeah.
And she's on the transportation board. And it's a term from February 28th, 2026. And she's Montpelier.
Yeah.
Do you want this?
Yeah.
Okay.
She's great. She's retired now.
From.
That's when she went. And then
Couple years.
Tim Pudva. Barb is from Shelburne. This is another transportation board. And it's his term starts February 28th. June 27th, 24 to February 28th, 27. And he's from Chittenden County.
I read out.
Yeah, I know you are. I didn't ask you. I didn't ask you.
You're the close.
I'll do it if you want. Just to clarify though, his term starts when?
Yeah, all of them.
June 27th, 24.
That's what they saw in
And
May.
it goes through
These guys
February.
don't know that yet?
They're
already on there.
They are,
Yeah,
We're just.
Maryland's on
reappointing.
there.
yeah, just reappointed. Just,
Okay,
this is just to call up, touch base,
okay, yeah,
yeah.
okay.
And you want us to report out on our votes by Friday? For the vote.
You know, we're in no rush to do this. So if you get, when people get through it, if they just go, I touch base, everything's okay. We'll just, send them up to the clerk's office and put it on the calendar. And these are the ones that we do batch. They go
Right.
by in the back and the Andy Shackney from Barry, and it's the Travel Information Council.
Yeah.
And Megan has all the phone.
Yeah, do you want me to email them to you or
Please,
write them down, email?
if you don't mind.
Email them to you.
Thank you.
Yeah.
And we will eventually get the secretary, all of the commissioners and those, and we will have all of them in.